So welcome to this week's webinar. We've had two really fantastic sessions with Irwin Mitchell regarding the litigation process, and they have been so informative. It's been absolutely fantastic, and we've all learnt a huge amount. And this is our third session, and it's the final session for this particular series. And we're going to be talking about what happens after settlement. I'm delighted to welcome Laura Middleton-Guerard, Katie Strong and Bronwen Lancaster from Irwin Mitchell. And I will pass you over to Laura.
Thank you, Sally. Well, first of all, thank you again to everyone who is joining us for part 3 in this webinar trilogy organised between Irwin Mitchell and Snap Care. As all of you may know, the third part in any trilogy tends to be the best, so we are hoping not to disappoint you at this lunchtime. So my name is Laura Middleton-Guerard. I am a partner in the serious injury team in London, operating from my living room, as you can see. I will be joined today by my colleague Katie Strong, who is a fellow partner in the Court Protection Department in our London office, and Bronwen Lancaster, who is a chartered financial planner working within IM Asset Management. Now, this part 3 focuses very much on life after settlement, and Katie and Bronwen will be taking you through a case study to highlight what happens once a case settles. And they'll be focusing on the case of a young boy called Dylan, who is 7 years old. Now, before I hand over to Katie and Bronwen, my role is very much to do a quick recap of how Dylan would have come to be in a position to settle his claim. Now, part 1 and 2 will have gone through all of that process in detail, and they will be on SnapCare's webpage, available to all. I'm not going to put anyone on the spot to ask what they can and can't remember from part 1 and part 2, but I do recommend that you view the webinars at your leisure. So part 1 would have seen my colleagues Sarah Griggs and Lauren Herney tell you how they would have investigated a claim such as Dylan's. Dylan, in the case study, was injured at birth, and what we tend to do as part of our role is to obtain as much evidence as we can, as swiftly as we can, to prove negligence, and in this case, on the part of the NHS Trust. Once liability is admitted, the focus then shifts on obtaining interim payments for Dylan, and that's essentially advances on his final compensation award. And the aim of that is to put clinical recommendations and care in place to maximise Dylan's recovery, but also to provide him with the best quality of life possible. And that's very much our USP, rehab, 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 using the litigation claim as a vehicle to generate interim payments to put all of that in place for Dylan. And it's through interim payments that we often come across SnapCare via our clients. So that's a very quick recap of part 1. I'm not sure I've done proper justice to what Sarah and Lauren went through, but as I said, everything is available online. Part 2 will have seen my other colleagues, Sophie Toft and Rebecca Cherry, talk about the various stages from the point where liability is admitted to settlement. And for Dylan, this would mean us getting every single piece of paper relating to his claim. Records, when he attended nursery, for example, getting those records, GP records, records from all of his clinicians. We've then obtained statements, and that, when we take over cases from other solicitors, I often find that that's an overlooked stage, but actually to me it's the most important one, because it gives parents a voice in the proceedings, to look beyond the records, to say, well, actually this is how Dylan's injuries are impacting us, the siblings, the wider community. And when experts refer to care and supervision, actually this is what it means in day-to-day life. And all of that is then sent to a range of experts who owe a duty to the court to set out what Dylan's needs will be, and what his care needs will be, how much case management he will need, how many hours of support by SNAP he will require going forward, the therapies he needs, the adaptations to his home so that he can actually access his own home, educational support so that he can access some form of curriculum and maximize his educational potential. Any lost earnings because of his injuries, any assistive tech, court protection costs, should he be deemed to lack capacity when he reaches 18, personal injury trust costs to help manage his funds, family law advice as and when needed. And all of that is looked at by way of evidence before we either head to trial to determine what Dylan will be entitled to, but that's quite rare. More likely than not, it will settle between the parties. And because Dylan is a minor, then that will require court approval. So there's always an element of court oversight in these cases. And then that's it. That's it from us. That's where our involvement as litigators end. I'm in touch with some of my former clients, so it's lovely to see actually how they've progressed beyond that stage. And I will often try my best to attend post-settlement meetings with clients and court of protection. But that's very much where the next chapter begins, where it will be very much Katie and Bronwen who will talk you through what happens once I fade out of the picture. And on that note, Katie, I've unmuted you. You're good to go.
Thank you very much, Laura. And thank you very much for that helpful reminder of parts 1 and 2, which leads on nicely to me, the third and final edition of the trilogy, and as Laura says, the best, hopefully, in the series. So if I can take control of the slides. I'm going to be talking to you today about the role of a professional deputy. My huge thanks to Snap Care for inviting me today to speak with you all, and thank you for joining me this afternoon. I hope you're going to find it helpful. This is going to be a real snapshot, and excuse the pun, I couldn't help it, of the Court of Protection. It's a topic I could talk to you about all day, with each element a topic of its own, but I will try my best to summarise it for you in a helpful package today. So as Laura said, I'm Katie Strong. I am a partner of Irwin Mitchell in the Court of Protection Department in London, and I'm also a director of the Irwin Mitchell Trust Corporation and the Irwin Mitchell Trustees Limited, which I'll explain a little bit more in a moment, but essentially that means I take on the role as a professional deputy or a professional trustee for our clients. Now, we are going to be talking to you about a case study, but before we do that, I thought it would be helpful to tell you a little bit more about the Court of Protection and what it is in its jurisdiction. So this court, in its current form, was created by the Mental Capacity Act 2005, and it exists to protect vulnerable people when they lack capacity to make decisions for themselves. And it's divided into 2 sections, the first being property and financial affairs, which is going to be my focus. It's my area of expertise and what I'll talk to you about today. But it's also useful to know that there's a health and welfare side of it, which deals with medical treatment, residency, care, and Irwin Mitchell have a public law and human rights team that specialise in that side of things. But as I say, my focus is property and finance today, leading on from the parts 1 and 2 about settlements that you've heard. Now, a deputy and the Court of Protection is certainly involved post-settlement, but actually it is involved throughout the litigation as well. And if you do or have seen those earlier talks, you will see reference to the Court of Protection, and you've heard Laura reference that the costs of a professional deputy is a head of loss that's considered in the claim as it's ongoing. So the court, what can it do? It can make one-off decisions and declarations or orders where it's only needed to make a one-off decision for an issue where a protected person lacks capacity to make that decision themselves. Or where I'm involved, and my area of expertise and my day job is essentially the appointment of a deputy. So the court appoints a deputy where there is a series of ongoing decisions that need to be made, and the court is essentially authorising someone, a deputy, to make those decisions on the person's behalf. Now, in terms of the Irwin Mitchell offering of that, I've mentioned the Irwin Mitchell Trust Corporation, and that is a body of 12 directors, all able to be professional deputies in their own right. And by that I mean they're able to be a named deputy on people's behalf. However, the Irwin Mitchell Trust Corporation has been created for practical reasons. Irwin Mitchell have a court of protection department that has nearly 1,300 deputyship clients, and so having a named person for each of those clients can be a little impractical. Now, we have a national presence, and we have a partner and a director across the national office base, but there will be a regular deputy. So, for instance, I'm in London alongside my fellow partner Julia Lomas, and for clients based in our area, we are the regular deputies that get to know our clients and make decisions on their behalf. But the advantage of a trust corporation is where one of us or both of us are not available, be it your health, holiday, or in case the worst happens, it doesn't mean that everything has to stop, and it means that decisions can still be made quickly and efficiently for our clients, because there are 10 other directors that can all become apprised of the situation and make decisions on our clients' behalf. So that is the Irwin Mitchell Trust Corporation, and how and why it's been created. The court can remove deputies who fail to carry out their duties, and that could be through misuse of funds or failure to apply funds in the correct way. The court can resolve disputes over enduring and lasting powers of attorney, and that is a whole different topic and subject area that will have to be for another webinar, but it does have power over lasting powers of attorney as well. And the court can enforce their own decisions within the jurisdiction granted to them by the Mental Capacity Act 2005. In terms of just a final thought on who can be a deputy, you can have a professional deputy, which is the services that I'm talking to you about today that Irwin Mitchell offer, but there are also lay deputies, and that's quite often family members. Now, a lay deputy is often appointed where there are lesser funds to manage, where we're talking about these large settlement sums that you've seen in parts 1 and 2, and the case study I'm going to be talking to you about today. The court will want a professional deputy required because of the complexities that you will see in managing a deputyship. Okay, so I will move on to the next slide and just tell you about the core principles of the Mental Capacity Act. 5 core principles is that there is an assumption of capacity. And that is essentially, the starting point is that at all times, the person is considered to have capacity to manage their own property and financial affairs. Now, that is unless there is evidence to the contrary. And if there is evidence to the contrary, then that authorises someone to make a decision on their behalf. All practicable steps must be taken to help people make their own decisions. And that can manifest itself in support. So, for instance, a speech and language therapist or a support worker that can be there to support and help someone in understanding what decision needs to be made and making the decision. A person is not barred from making unwise decisions if they have capacity to make that decision. All decisions must be made in a person's best interest, and decisions must be taken in the least restrictive way. Now, there are 2 phases of the test as to whether someone lacks capacity. As the starting point is this assumption of capacity that's decision specific. So a person lacks capacity in relation to a matter if at the material time, so at that point in time that you're assessing them, they are unable to make a decision for themselves in relation to the matter because of an impairment or a disturbance in the functioning of the mind or brain. We then move on to the not too fast, we move on to the second part 2. And this is setting out where a person lacks capacity to make a decision if they are unable to understand the information that's relevant to making the decision, retain that information for the period that they need to in order to make a decision. So they don't need to have the ability to retain it for forever. They just need to have the ability to retain it for that period that they need to use or weigh information up to make a decision, and that's the next one. They need to be able to have to recognise the advantages and disadvantages and weigh up all the information as part of the decision-making process. And they must be able to communicate their decision, whether by talking, using sign language or other means. And quite often we bring in the assistance of speech and language therapists to help us with capacity assessments to do everything we can. Going back to that first that first section of core principles of the Mental Capacity Act, all practicable steps must be taken in order to allow someone to make their own decision. So that's where you do everything you can to support the person to make their own decision. The mere fact that someone makes an unwise decision is not necessarily to be taken as showing they lack capacity. An example of this is a client that we have recently had settlement on, had a budget agreed at his post-settlement meeting for a car. He's heavily into his cars, loves them, and this is what he's been waiting for. So we set a budget for that, and he was going to go out and buy a new car. And as he made some inquiries, he came back to me and said, actually, I'd like to buy a heavily modified old Mini. And he's had Minis before, and they've cost a lot of money before, and we've talked this all through. But he is fairly high functioning. He has capacity to make this decision, although I think it's unwise. He has a budget and he's been allowed to purchase that Mini. And I'm sure you can all guess how long it took for the bill to come in for the first fixing job. Was around about 3 days, bless him. So if someone is assessed to lack capacity, so you've taken into account parts 1 and 2 of the test, and it's considered that they do lack capacity to make this decision themselves, then a deputy needs to make the decision on their behalf. How we go about that is set out in section 4 of the Mental Capacity Act, and essentially it gives you a framework of what we need to consider, and that's equal consideration and non-discrimination, so no assumptions made, all the relevant circumstances. It's never black and white. There's always the grey areas that need to be taken into account. Regaining capacity, if it's likely the person's going to regain capacity fairly soon, can we wait for this decision to be made? Permitting and encouraging participation and wishes and feelings of the clients, as well as his family and those that have an interest in his welfare and decision making. Going to the next slide, which I seem to be struggling with, Sally. Thank you. Okay, so this is Dylan. Dylan, as Laura mentioned at the start of this presentation, is 7 years old, and he's suffered catastrophic injury and a severe traumatic brain injury at birth, and that was a result of medical negligence, and a claim has been made against the NHS Trust. He's severely disabled. He has 4-limb cerebral palsy. He's unable to walk or mobilise independently. He has difficulty communicating, and he's largely non-verbal. He requires 24/7 care and support that's provided in part by a care team, but also by his parents. And Dylan lives with his mum and dad, David and Sarah, and his sister Lily, in rental accommodation, as his home was not suited to his needs, so the family had to move during the litigation process. A deputy was appointed for Dylan during the litigation process, as it was considered and assessed that when Dylan reaches the age of 18, he is likely to lack capacity to manage his own financial affairs. And so a professional deputy was thought to be required at that stage, at this early stage, while Dylan is a minor. Again, there's a whole different subject area on when a professional, a personal injury trust is required with a professional trustee appointed, and that's in cases where capacity is unknown when the person is going to reach 18, or where it's considered that they will have capacity at the age of 18, and the settlement awards need to be ring-fenced. As I say, a completely separate topic on its own, and one I'm happy to come back and talk to you about. But keeping to Dylan and his family and the deputy being appointed. The cost of the professional deputy has been a consideration during the litigation, and so that's been recovered as a separate head of loss. So the settlement itself. Next slide, please, Sarah. Sally. Thank you. Dylan's settlement. So he has secured a great settlement, 3.8 million net, and that's the amount that's going to be paid across to the deputy account, having taken off the interim payments made during the litigation's life, and any payments that need to be paid back, CRU payments. He's also secured periodical payments, and periodical payments are usually, not always, but usually calculated for the care and case management head of loss. And you will see that there are stages where there's a step up in the periodical payments associated with a certain age that Dylan reaches. And usually that's where the claim has envisaged Dylan's needs are going to increase as he gets older, and that can be as he gets larger in size, and his needs may mean, and his size and his growing may mean that he no longer needs one-to-one support, but he needs two-to-one support. Hence, the periodical payment that covers this care and case management head of loss increases. And as he gets older still, it may be thought that his medical needs are going to be far more complex, again attracting a higher cost of care. So this is the settlement structure that's been secured for him. And at the settlement point, it's been referred to by Laura already, but the deputy will arrange a post-settlement meeting, and that's the handover stage from the PI team and Laura's involvement to the deputy team, as the PI team will now step away. And that post-settlement meeting is to go over the settlement and to look at counsel's advice on what's been recovered under each head of loss. Again, that Laura gave a helpful summary of. And we discuss and agree how we're going to budget. And my job is essentially to make sure that the settlement is going to last Dylan's lifetime. Next slide, please, Sally. Thank you. So this is a bit of a snapshot of Dylan's financial timeline, and you can see his age at the bottom of the graph. And I just wanted to talk to you about the key topics and the regular sort of issues that we deal with as a deputy, to give you an idea of what our role is, and essentially the massive wide remit that we have as we fit into people's lives. And obviously everyone has different circumstances that need to be taken into account, and a bespoke service offered. But you'll see a key feature across the board is employment, and we have a very good and existing relationship with SnapCare in respect of employment. It can come in two forms. We can either directly employ, and that's where we have the assistance of SnapCare to recruit, to find suitable candidates, which is a tricky task in itself. But we look at directly employing, and when we directly employ, the deputy essentially is the employer on Dylan's behalf. So we will send out a contract of employment. We have the statutory obligations of an employer. We have the responsibility to pay into a pension. We have the annual leave responsibility. We have the responsibility to ensure that their training is up to date, their DBS checks are up to date. All of that side of things needs constant monitoring, and that obligation would fall to the deputy as the employer. And the employment team is a changing thing. There are cases where you have very settled care packages for a long period of time, but there's the inevitable changes as people move on and things change. And so there is an ongoing oversight of employment and an ongoing recruitment process that's factored in when we are budgeting going forward for the cost of care. And that's often trying to be budgeted into that periodical payment amount for care and case management that I've talked about. The other method of providing a care team is agency care. Sometimes that's the first port of call to get families used to accepting care and support, as they've often had to cope for themselves for a very long period of time. And so it's a method of introducing it. And sometimes actually, once you've done an analysis, it may be that agency is more suitable to the client's circumstances. But that's a decision that the deputy makes alongside parents and the client, with case manager input. And a case manager, I'll feed into at the end, is a person that is going to be needed for a care package the size of Dylan's to essentially coordinate all the elements of this care package that will be needed. Often at the point of settlement, there is a discussion about purchasing a property. And in Dylan's circumstances, he's currently in a rental property waiting for settlement. And so we have a look at what's been recovered in terms of the claim, and we set a budget on what we can afford to buy a house with. And you'll see for Dylan, we've set the property budget at 1 million. More often than not, adaptations are needed on behalf of our clients, and we manage that process as well. So the deputy will be the person that owns the property on Dylan's behalf. So it'd be Irwin Mitchell Trust Corporation acting on behalf of Dylan, and they would be purchasing the property, and they go through that purchase process, and we deal with the conveyancing and all aspects of the searches and surveys and the actual process to buy it. And then once we've bought it, we look at the adaptations. And in the purchase process, we usually get an idea of what the adaptations are going to cost so that we know it is in budget. And this involves the instruction of surveyors and architects to come in and look at the property. They coordinate with an occupational therapist and case manager often as to what adaptations are needed to make this property suitable for Dylan, and then they cost it up. Once we've bought the property, the works then start, and we enter into contracts with the project managers, often qualified surveyors and architects, to project lead, and we then enter into contracts with the contractors and tender the process. So again, these are all topics in their own right, but as a snapshot, we produce a tender, a specification of works that are needed. That's sent out to 3 contractors. We pull that in, we look at what the best one is, and we instruct a contractor and manage the adaptation process. And to support us with that, we have a building consultancy team in-house with qualified surveyors and architects to monitor that process and assist the deputy with it. So that's the first sort of key purchase and a big one. And then you'll see that I've given examples of a vehicle being required throughout Dylan's lifetime, as the lifespan of a car, 5 to 7 years is usual. So purchase of a car is needed, and again that involves all of the MDT team, the multidisciplinary team surrounding Dylan, such as his OT, his physio, his case manager, his parents. And so we routinely purchase cars and adapt them, make them suitable for Dylan, as he is reliant on his wheelchair, and he does need to have his wheelchair safely secured into his car. At the age of 18, you'll see that I've put a statutory will there. And as a deputy, we have a responsibility to ensure that our clients' will affairs are looked into and catered for. And essentially, we're responsible for looking at what the intestacy provisions would be, whether they're sufficient or whether a will needs to be made on Dylan's behalf. Now, capacity, as I've mentioned, is decision specific. And so a capacity assessment called a testamentary capacity assessment would need to be undertaken to see if Dylan can make a will himself. And if he can, he will do so in the usual way, and it falls outside the remit of the deputy. But if he lacks capacity, then it still falls under the Court of Protection's remit and jurisdiction, and the deputy will propose a suitable will, having consulted with Dylan and his family, make a proposal for a will and send that to the Court of Protection. Again, a subject in its own right, but essentially the Court of Protection appoints the official solicitor to act on Dylan's behalf, and the process goes through the court to make sure that a suitable will is executed on Dylan's behalf that align with his wishes, or what we think his wishes and feelings would be. Said that I've disconnected, but I hope that I'm back. Sally, if you can confirm you can hear me.
Yes, we can. We can't see you at the moment, I don't think. But
right.
Yeah.
Okay, sorry about that. That was a heart-stopping moment. Okay, so you'll also see that I've mentioned equipment in there, and this might be a good moment to introduce the case manager to you as someone who coordinates a multidisciplinary team of therapists. Dylan is likely to need physiotherapy, speech and language therapy, occupational therapy, perhaps hydrotherapy, and all of these therapists need to come together and work together. And the case manager coordinates them essentially. And the therapy team and the clinical team will be advising me, the deputy, on what equipment needs that Dylan may have, from wheelchairs to trikes to standing frames to comfy chairs. A huge range is available that caters for our clients, and essentially the case manager is the pinpoint of getting the recommendations from the multidisciplinary team and putting them to me. And these are all aspects that are also factored into the claim in parts 1 and 2 that you've heard. These are all sort of factored into those heads of loss, and I've always got an eye on what's been recovered. But the post-settlement, it's a global budgeting process that I'm managing to make sure that overall things are going to be affordable for Dylan's lifetime. And whilst I have an eye on what's been recovered, I don't stick to that by the pence and pounds as things change and needs change, and it's ensuring that the whole pot is going to last his lifetime, and we can ensure a quality of life for Dylan and purchase everything that he needs. Okay, so that's a snapshot for Dylan, and as I say, in those periodical payment increases, his circumstances may change and care packages may change and adapt, so it's a moving feast. Other little pictures that I've thrown up there is that the deputy is responsible for tax returns, and whilst Dylan wouldn't have to pay tax on his actual settlement award, he would be responsible for any interest that is or income that's payable from his settlement, and that's very much linked with the investment process that I'll talk to you about in a moment. But we prepare the tax returns on Dylan's behalf. We deal with and settle household bills. And we can also deal with gift requests if Dylan wants us to make a gift to sisters for their birthdays, for instance. We also have authority to deal with that up to a certain point. Some things do need referral back to the Board of Protection, but that's a very quick snapshot of a regular financial timeline. So next slide, please, Sally. Great, thank you. And this takes me on to investments post-settlement. And this is a topic that's also discussed at the post-settlement stage. And once we have budgeted at the post-settlement, we are looking at essentially what the immediate capital expenditure requirements are for Dylan, such as purchasing a house, such as purchasing a new car, equipment needs, things like that. And we plan what that cost is going to be. The starting point for investments is that you don't want to be investing anything you're going to be needing in the next 3 to 5 years. And so we are looking at what's left after we've factored in these immediate costs. And we look to whether those should be invested. And the aim of investment is not to make millions, but it's to make sure that the settlement lasts for Dylan's lifetime. And there is a huge risk at the moment of not investing, in that inflation is on the rise and expected to increase quite dramatically in the next few years, and cash-in rates are at an all-time low. So if the bulk of that lump sum that Dylan has secured is sat in national savings and investments, for instance, with an interest rate of 0.01%, the impact of inflation is going to deplete the value of the award, and so it's a little bit of a silent killer, and it does quite often in Dylan's circumstances mean that there is a need to invest to ensure that you keep pace with inflation and keep the settlement award maintaining the value, its buying power that was intended at the point of settlement. And this is very much going to be what Bronwen is going to be talking to you about this afternoon. But from my perspective, the deputy is looking at low risk investment. The target is to make sure the fund lasts a lifetime and beats inflation. It's not to make millions, so it's low risk, and it's a very fine instruction to give. And we have a panel of approved fund managers that have all passed our due diligence. They are all caller protection specialist fund managers in their own right. So it's not just approaching your average investment advisor from the high street. They are caller protection specialists, and they understand that there is a need to secure this money and it can't be lost. They are invited to pitch their proposals to the deputy and the client and family, and they are all compared against each other. So usually we have 4 investment managers that come and give their proposals as to how they would manage Dillon's funds, and at the end of the day we compare the key points between them all, and we select someone to instruct. Now, Irwin Mitchell Asset Management come under the umbrella of Irwin Mitchell LLP. They are a different group to the deputy, which is under the solicitor's firm, and Irwin Mitchell Asset Management is its own entity. However, if Irwin Mitchell are invited to pitch, there has to be family in attendance, is the first and foremost, and they are treated the same and have exactly the same information as anyone that they are pitching against. And that's to get rid of a perceived conflict of interest, essentially, between Irwin Mitchell being the deputy and someone under that group being invited to invest. And so they are only invited where family members are going to be making a decision alongside the deputy, and they are judged in the same way and on the same comparison information. So what better time to hand over to Bronwen with my thanks.
Hello. Can anyone hear me?
We can all hear you, Bronwen.
Yay. Okay. Well, thank you very much, Katie. That's fantastic. So I think that leads really nicely into my part. And first of all, I'd just like to thank you for inviting me to speak today, as Katie did. It's lovely to be able to speak to everyone, and hopefully you'll find this helpful, as I'm sure you have already. My name is, Sally, could I just pop you onto the next slide? Would that be okay? Thank you. My name is Bronwen Lancaster. I'm a chartered financial planner. I've been giving financial planning advice and guidance now for around about 17 years. And over that time, I've developed a specialisation in advising vulnerable individuals and those who lack capacity to manage their own affairs and their legal representatives. And over the last 7 years, I've been involved with predominantly giving financial planning advice and guidance to claimants in personal injury settlements and their legal representatives. So I am Asset Management. Katie has already signposted. We're a wealth management firm. We are part of the Irwin Mitchell umbrella. So we are part of the group, but we are a separately regulated legal entity. So we're a limited company in our own right, and that's because we're regulated separately under the wealth management industry. So we were established by the partners of Irwin Mitchell about 20 years ago, simply in recognition of the fact that they were settling large claims for individuals, and in some cases sending them off into the big wide world with lots of really important financial planning decisions to make. And simply they just wanted to make sure they had access to the very best financial planning advice. So Sally, can I just move you on to the next slide? Oh, can I go forward another 2? Is that okay? Lovely. Okay, so wealth management. I put this slide together just to say what wealth management is, but simply wealth management is a combination of financial planning and investment management. So at IM Asset Management, we have about 50 individuals, 50 employees working, and we have financial planners who are involved with making decisions about somebody's financial strategy. So we're looking at what our claimants, in this case Dylan, needs. how best to structure his financial arrangements to make sure that money is available for those particular needs when he needs to. We look at minimising tax, and we look at the solutions to making sure that Dylan's financial arrangements are managed to maximise sustainability.
Bronwen, I'm sorry, Bronwen, we're losing your sound a little bit.
We also have in-house investment managers, and our okay.
I'm sorry, Bronwen.
Is this a bit clearer now?
I think it is. Yes. It was
Can you
just
hear me now?
Yeah. We might just ask you to turn your video off if it continues, because I know we had a little bit of a problem in the run-up. So, but
that's not a problem at all. That's not a problem at all. So we also have in-house, we have investment managers, and our investment managers are managing our clients' monies on a day-to-day basis. They're investing into stock markets and taking opportunities to grow our clients' wealth where they can, but also being very careful to manage the level of risk that our clients are exposed to make sure that they're not exposed to unnecessary losses that might arise. Ultimately, with the view of making sure our clients' wealth grows and is sufficient to meet their lifetime needs. At the moment, our investment management team manage over £940 million of client monies. It did pip over 1 billion at one point a couple of months ago, as markets do move, but 95% of that 940 million that we look after is managed on behalf of those who settled a personal injury claim, and a good chunk of that is managed on behalf of those who lack capacity to manage their own affairs, and so their affairs are being looked after by a deputy like Katie. I think what's really important to say is that all of our investment managers, our financial planners, our support, we're all qualified to one of the highest possible levels of attainment in our own specific field, which is financial services. But actually, we're all very fluent in the legal language. We get involved heavily during the litigation process in some cases, so we have a really good understanding of the journey our families have been on to reach settlement. And we hope that means that we tailor our financial planning so that it's much more suitable, because our clients' needs are very different to that of a typical investor. So everything we do always has that in mind. And with that, another hat I actually wear, and this touches a little bit on pre-settlement, is I'm actually an expert witness to court as well. So when we're talking about the structure of client settlements, and Katie mentioned with Dylan specifically that he had been awarded periodical payments as well as a lump sum settlement, part of my role is to advise the court before the case settles as to what that structure would best look like, and to make sure that we're having the best strategy to meet his long-term financial needs. Can you still all hear me okay?
Yeah, all good.
Okay, lovely. Can I pop onto the next slide, please, Helen? Sally, sorry. Okay, so actually, can I take you back 3? Okay, that's perfect. So I mentioned to you earlier that financial planning, wealth management is a combination of financial planning and also of investment management, or solution, if you like. So this little graph is very busy, but it's designed to discuss what happens effectively to someone's financial position when a serious catastrophic injury happens, or when someone unfortunately is in a position where they give birth to a child who has severe disabilities. So in Dylan's case, what we're looking at is for many of us, we're earning, our income levels are probably just about covering our expenditure. If we're lucky enough, we're saving a little bit towards our future, and that tends to be or paying down our mortgage, and that tends to be the way most of us live. But when someone has a catastrophic injury of their own, or in Dylan's case, you've got a child who's come along with severe disabilities, it turns your whole financial situation on its head. And certainly in Dylan's case, his mum, Sarah, once Dylan was born, she was no longer able to carry on with a career as she might have done. So the family lose that level of income that they would have had before. And at the same time, that level of expenditure they have goes through the roof, because Dylan has considerable care needs. He needs to have care support, he needs therapy, and all of these things. So what we see is a huge flip around in someone's financial position. So suddenly their expenditure is far in excess of the family's income. And we have this huge gap to fill on a yearly basis. And my job as a financial planner is to look at our clients' financial resources and to understand how best to fill that gap and make sure it's sustainable throughout the entirety of their lifetime. And in Dylan's case, that blue square with the pound sign on it is his settlement effectively. So my job is to understand how best to use that settlement to plug this gap for Dylan and for his family. Can I move on to the next slide? Is that okay? Okay. So one of the first things we do as a financial planner is we look at cash flow forecasting. So what we try to do is understand, based on our clients' current circumstances, their current income and their current expenditure and their needs that we see coming up, what is their financial position looking like over time? And we try to make an estimate of how Dylan's expenditure may change over the course of his lifetime. And I think what's really helpful, certainly for myself, is being involved in the litigation process and having given advice to court and understanding that Dylan's care needs are going to go up at a certain time. Certainly when he's age 18, his periodical payments have been increased to reflect that he's going to need higher costs of living. He's going to potentially live independently with care support, so his care needs are going to increase substantially. We need to factor all of that in and try our best to guess what Dylan's financial future might look like. And in many cases, although you have a periodical payment for someone like Dylan who would cover his most essential costs for care and for case management, there are other bills that Dylan will have to pay, the same bills that we all have to pay for our gas and our electricity and cars and things that Katie was talking about earlier. So by and large, even if we've been lucky enough to secure a periodical payment for our clients, there's going to be expenditure over and above those, which will eat into that lump sum of 3.8 million every year and will erode the value of his settlement. And I think, you know, the one thing to get our head around with many of our clients is, you know, Dylan's had a settlement of 3.8 million. He's also got a high level of income each year. And that sounds like a huge amount of money. But for someone with the level of care need that Dylan has, that sum of money needs to be very carefully managed and looked after, because it can quite quickly erode. And we do have a position where we have clients who we feel are very financially secure, but actually there's a very real possibility that they could run out of money. So my job is to manage that situation alongside the deputy in Dylan's case to make sure that doesn't happen effectively. So just to explain this graph a little bit, we've got Dylan at the start, age 7, and he's got £3.8 million held in cash. Now, the reason there are 3 different lines is what we do as a financial planner is we assume a rate of growth on that money. So we factor in inflation, which is really important, and Katie touched upon that earlier. We need to know how the cost of living rises are naturally going to erode the purchasing power of Dylan's money. But we also need to understand if he achieves a certain level of return on that money every single year, how will that impact upon how sustainable his position is? So the bottom line there, which is sort of a reddy colour, that's if we were assuming that Dylan's pot of money grew at just cash rates. So for this purpose, I've assumed 1.5%. Now that's because the FCA, my regulator, or our regulator, assumes 1.5% growth rates as cash rates. The reality is that we haven't seen cash rates like that for a couple of years, really. In reality, you're very lucky if you get more than 0.1% in a cash account nowadays. So what you can quite quickly see is looking at Dylan's projection, you know, it's showing that were his money to achieve a growth rate of 1.5%, actually there's a good chance that his liquid money would run out by the time he gets to age 45. Now, that dip there in the graph is where we're buying property. You know, we've earmarked 1.3 million for a property and for adaptation, so it factors in that expenditure that's coming off. But you can see, you know, it's not as clear cut that such a fantastic settlement will be sufficient to meet needs without taking an investment decision. And I think quite often we have families who get to this stage who don't understand why they necessarily have to start thinking about investing their child's hard-earned money. You know, it's been a long battle, sometimes 7-10 years, trying to get to get money and settlement monies for their clients, and the thought of investing that money and potentially putting it at risk is really frightening for families. But the reality is the deputy has to be minded to make an investment decision, because unless you do, there's a good chance the money won't do what it needs to do over the longer term. So if we look at the middle line, where the monies are projected to last a lot longer, we're looking at a 4.5% growth rate. Well, what that means is if we want Dylan's financial position to be sustainable for as long as possible, ideally we need to get his wealth growing by 4.5% a year in order to stand its best chance of lasting his lifetime. And that's where investment management comes in. Okay. Can I pop to the next slide, please, Sally? Okay, and on again. I've already done that one. Okay, brilliant. So we already know that Dylan has a need to invest, and I think another thing that I'd really like to say that's important here is, and Katie touched upon it earlier, is even if there was no need to invest and there was showing all of those lines were going upwards rather than downwards, we still need to very strongly consider investing in the current climate, because if money sits in cash for a long time, it does lose its purchasing power. Cash accounts are paying 0.1% at best at the moment, certainly for large holdings of money. And we know that inflation ordinarily is around about 2%. And I chucked together a couple of figures, which I thought were quite powerful. But actually, in Dylan's case, if you were to hold £3.8 million in a cash account earning nothing over a period of 5 years, in terms of its buying power, in 5 years' time, it would have reduced to 3.43 million. So it would have lost £365,000 worth of its buying power over 5 years if it was just sat in cash. Similarly, if we projected forward over 20 years, and bearing in mind lots of our clients are children and we hope that they'll live 20, 30, 40 years, £3.8 million held earning nothing for 20 years, its buying power, assuming 2% inflation, would be reduced right down to just over £2.5 million in 20 years' time. So that's a loss of buying power of 1.26 million. And I think those figures are really powerful, because if I were to be handed an investment of 3.8 million for a client and it were to lose 1.26 million over 20 years, the family and the deputy would rightly be knocking on my door saying, what on earth have you done? What level of risk have you taken? But Katie's absolutely right. Inflation is a silent killer that creeps up on us. And we know that if we have any chance of beating inflation at the moment, we have to look at investing our clients' assets. Even if it's with a really low risk approach, we need to make that decision to invest. Okay. Can you still all hear me okay?
Yes, we can.
Okay, fabulous. Okay, so turning back to Dylan, the first thing that we do is, now we're understanding what we need to do in order to give Dylan's money the best chance of lasting its lifetime. The first thing we need to do is have a look at his short-term needs. What does he need in the next 6 to 12 months? Then we need to have a think about what does he need potentially in the next 3 years, 3 to 5 years. So when we were looking back at Katie's timeline, what costs, how many times will he need to buy a car in the short term? Is he buying a property? What does he need to set aside for adaptations? When will there be a stat will? And we need to have a little look and see when all of these costs are going to arise. And in Dylan's case, he's going to need around about £85,000 to meet his expenditure needs just over the next 6 months. So we need that to be readily accessible to him. And periodical payments are only paid annually. So once they're in, we need to keep them available to pay day-to-day bills. So the deputy is needing to pay the care teams. The deputy needs to be able to access money very quickly to pay for therapies, just to pay for day-to-day bills in a new property. So we need to make sure that we've got £85,000 sat there for Dylan that the deputy can get their hands on very, very quickly. It won't earn very much at all, but that's not the purpose for it. It's not going to be there, sat there long enough to earn anything. So we put that to one side in a bank account. And we also look at what we need in the medium term, which is this 1 to 3 to 5 year gap in some cases. Although with interest rates being so low, we try not to keep anything that we need past 3 years in reality at the moment, because it does sit there and lose its value. but we know Dylan's going to need he's going to need a house. He's going to need to pay for adaptations for that house. He's also going to need to meet his costs over and above that which his periodical payment provides. And he's also going to need a rainy day pot of money. So we need to make sure there's money set aside for contingencies, any unforeseen things that might arise that we haven't planned for or the deputy hasn't planned for. So we would keep that in a medium-term pot. And in Dylan's case, I've earmarked an amount of 1.215 million. Now that would stay in a cash pot until it was needed, but we would make sure it was held in a cash pot that provided protection. So I won't go into too much detail, but when we're holding large amounts of cash, we need to make sure that the institutions holding that money are secure. We know that banks are only insured up to £85,000 per individual. So ideally, we don't want to hold more than £85,000 in any one bank for Dylan. There's always a risk that that bank could collapse and that he wouldn't get back what he's insured amount of 85,000 is. So as a financial planner, we would look at that medium-term pot. We would want to keep it safe, but we would be proposing to the deputy a safe haven to keep it in where it was protected from institutional failure as well. In terms of our longer-term funds, and in Dylan's case, I've earmarked that he would have a sum of approximately 2.5 million, which would be available to invest. And that would be money that he doesn't need in the next 3 to 5 years. And that's the pot of money that we want to get working and try and achieve that 4.5% growth rate so that it stands the best chance of being worth what it needs to be to keep his financial position going for as long as possible. Okay. Can I move on to the next slide, please? Okay, so how do we invest? So we've earmarked a sum of 2.5 million for Dylan. Now, we haven't really got enough time to go into the intricacies of what a discretionary fund manager does, and I wouldn't be doing them justice if I tried. But in essence, a discretionary fund manager invests our clients' money into a selection of different assets and manages those investments to try and maximise the opportunity for growth, but also to try and minimise the exposure that investment has to market losses or volatility. Very, very roughly speaking, there's 4 main asset classes that any individual would look to invest in. And those are cash, fixed interest, stocks and shares or equities, and property. Well, for Dylan, we'd already be heavily invested in property because we've already set aside that Dylan would have up to 1.3 million to buy a property and to adapt that property. So he already ticks that box of having exposure to property. And we know as a financial planner that over the longer term, property prices do go up. We also know that property is fairly inaccessible for spending. So you can't sell property off in parts, but obviously everybody needs a home to live in. So Dylan will already have ticked that box. So our job as investment managers then is to look after the other 4 main asset classes that you would invest in, which is shown on the screen there. Now, I won't go into too much detail on this at all, but all of the different things that we invest in carry a different level of risk. The lower risk style of investments are cash and fixed interest, and then stocks and shares tend to be anything from sort of low risk all the way up to high risk, depending on the sort of investments that are needed and the level of growth. And obviously, the more exposure to risk of loss that an investment has, the greater the potential for return from that. So if we want to achieve a 4.5% return for Dylan every year on his investment monies, we're going to need to take some risk in order to achieve that return. But also we know how hard it has been for our clients to achieve these settlements and for the litigation teams to achieve these settlements for their claimants and for Dylan. So we don't take a large amount of risk, and importantly, we know how important this money is. It's there to meet very vital needs for care, support, and the things that Dylan really needs to have a good standard of living. So we don't tend to look very much at these higher risk investments. We tend very much to play in the sort of low to low medium risk investment strategies across the board. Okay, can I move on to the next slide? Is that okay? Okay, so In terms of the way we manage money, we're managing money on a day-to-day basis for our clients, and our investment management teams are watching the markets from the moment they open to the moment they close, looking for opportunities to buy things that are growing and moving in the right direction for our clients, and they're also looking for the opportunity to avoid loss, to make sure that we're preserving the value of what our clients ask us to look after. I thought it was really, really helpful because we've been through a really volatile market time, to give a snapshot of the value of that active discretionary fund management and how it works when you're in very, very volatile markets. I think the one thing that I've noticed increasingly over the last year, certainly 15 months, is families who are settling claims for their children or for their loved ones are very nervous about the idea of investing into a market when we're watching the FTSE 100 flying all over the shop on the television because of everything that's been happening with the pandemic. But actually what we've seen and what we know as financial planners and investment managers is that actually volatility is a really good way to manage and maximise growth for our clients. And whilst it can be quite scary, the best thing to have when you have volatility in the markets is to have fund managers who are actively monitoring the money, taking their discretionary decisions to act in the best interest of our clients all the time, to buy and sell the shares that they hold for our clients. So I wanted to give a snapshot, and I know graphs aren't always the greatest, but to try and illustrate how good discretionary fund management works for clients when we've got volatile markets. And what I've tried to do is I've looked at a snapshot of how the FTSE 100, which is the top 100 by capital size companies in the UK, and how their shares performed over the course of the 9 month, the year up until the 30th of September last year, because that was the very, very volatile period during our financial markets. And I wanted to compare it to how our sort of lowish risk investment portfolios performed compared to that FTSE 100, to show how we're able to navigate and manage that volatility to make the most for our clients and make sure that they're not losing when the markets are losing. So if you have a look at the 12-month period to the 30th of September 2020, and a huge amount happened, of course, during that period, but you can see that the FTSE 100 actually lost 21% of its value over that 12-month period. Now, if you had just settled a claim for your child and they lost 21% of the value of that capital investment within a year, you'd rightly be very, very worried. But actually, if you compare it to a low risk investment strategy, which I have done on the side, over the same period, our balanced income strategy was actually a little bit up. So although the market was 21% down, because we were able to manage that position and look after our clients' interests as best as we could, although our clients hadn't made very much, they were about 0.5% in positive territory compared to 21% down. Over the 6-month period to the 30th of September, we had the vaccine rollout. So the vaccines were announced and discovered, and actually the FTSE 100 flew forward, and actually over that 6-month period to the 30th of September was actually up about 5%. Our fund managers were able to capitalize on that momentum, and actually our clients who were in this particular portfolio over the same 6-month time frame were actually up about 12–13% over that same time frame. Hopefully what that illustrates to you is that when the FTSE 100 was down, when markets were really low, we were taking stock of what our clients had and protecting it as best as we could and making sure they weren't exposed to those losses. But likewise, when there was opportunity for growth in the market, so when the FTSE was up, our investment strategy was up by quite a bit more because we were taking advantage of that. So I always feel that this slide has been really helpful in the last year to sort of allay the concerns of families who are thinking about the investment of their children's settlement, to say, if you've got a good discretionary fund management strategy, you will be able to navigate that volatility and that you will be able to achieve positive returns, hopefully for your child, for the claimant. So if you could move on to the next slide, Sally. Okay. So we talked a little bit about investment management, and I have to say it's a bit of a whistle-stop tour because I'm conscious we've gone over as well for time. There's obviously a huge amount more that goes behind the scenes, but I hope that gave you a taste of what we do and how we manage our clients' financial position. On top of investment management, we are a full financial planning service. So when we're looking at managing money for Dylan, we're also looking at mitigating unnecessary taxation, making sure that he's not paying too much in tax. We would far rather save unnecessary tax for Dylan than take extra risk with his investments to get that same level of growth. So it's all about looking after the pennies so that the pounds look after themselves. Pension planning will assist the deputy to make sure that if Dylan is able to make the use of tax efficient pension planning, we'll do that for him from an early stage. We'll look at ensuring key individuals. So Sarah, for example, is really key to Dylan. She's providing care for him every day. If she wasn't able to provide that additional care, he would have to be paying for additional care from paid care workers. So we'll always look to ensure those key people in Dylan's life to make sure that if anything happened to Sarah, there would be replacement funds to come in to replace that loss of support and care that she's able to give. Estate planning, we don't do a huge amount of with our clients who lack capacity, because ultimately the claim is there for them during their lifetime. So we're not interested in building a huge estate but to pass on to their loved ones after they're gone. But if it does come into question, we can give that sort of estate planning advice as well. And importantly, because of that level of expertise we have in working with the litigation process, we also provide a periodical payment checking service. So our clients that have been lucky enough to secure periodical payments for their lifetime, we make sure that those are being increased each year by the correct amount, because they do get it wrong, and when they get it wrong, it does tend to be large amounts of money each year. So we make sure we check the amount of payment that's coming in every single year. We go back to the deputy, and if we think that amount's wrong, we'll let them know, and the deputy will go back to the NHS in this case and point out that there's an error and ask for the difference. Okay, so overall, we tailor everything internally to suit our clients. I think I mentioned already that 95% of the clients we look after have received personal injury settlements. We do set everything up to make sure we're catering for those clients' very specific needs. There is a lot more to it, but hopefully this has given you a bit of a taster of the sort of things that we do. And if you've got any questions at all, please don't hesitate to ask.
Wow.
I think that was going to be my opening word, Janet, as well. It's like I didn't actually know just like what a wide kind of like, you know, range of things that you guys were doing for this, because that is quite amazing. It
is incredible.
Yeah.
I don't know if it's a question or it's an observation, perhaps for Katie actually, because you have, it's so complex, and the money that you're looking after and sort of spending correctly for your client, we will sometimes come across deputies who will look at our figures, our hourly rates, and say no. But in fact, if they did that and said yes, because you're paying for very good quality, then the longevity then would eventually save your client money.
Mm-hmm.
Because sometimes we have this battle going, please, if you can just pay them what they really are valued at, that person will stay 2 to 3 years instead of spending money on an agency.
Well, yes, and I suppose a follow-on from that is if you're not paying the going rate, you're going to have more staff turnover, and then the recruitment costs are going to deplete the saving you thought you were making in the first place. So we certainly do take advice. From my perspective, my starting point is the case manager advising me what the going rate is in the area, and I have a look at whether that's going to come in under the periodical payment amount that's intended for care and case management. But as I mentioned, it's not the be all and end all. Once it's settled, we're looking at a global budget and affordability globally. So I completely hear you, Janet, that sometimes it's not cost effective to try and undercut and pay less, because that can lead to higher costs in recruitment, and agency fees are obviously well over a direct employment hourly rate. So I'm with you on that one.
Right, thank you.
So are there any questions to be read out? Would anybody like to add any into the chat? I think everybody's sitting there trying to kind of absorb all of the information.
I actually do have another one for Katie, and it's very interesting because you mentioned lay deputies. What qualifies a lay deputy? I know you talked about money, but how do you find that person to be able to do that job?
It's not really any qualifications. When you are applying to be a deputy, and usually a lay deputy will be identified as the person's immediate family. So it'll be mum, dad, it'll be a daughter of mum who may have developed dementia and be going into a care home and need her funds managed. So it's not routinely found where we've got these large sum settlements, because for all the reasons we've gone through today, it is complex managing an award that large, and the Court of Protection just simply won't appoint a lay deputy to manage a large settlement award. But where you've got lower value awards, or where you've got the circumstances where a family member becomes ill and there isn't a huge estate to manage, and it may be selling a house to pay for care fees, then that's when you find lay deputies being appointed. But they are subject to the same scrutiny as a professional deputy by the Court of Protection. So when you are applying to be a lay deputy or a professional, you sign up to a deputy declaration, which is very onerous. You need to keep bank accounts separate. You need to be fully apprised of the Mental Capacity Act. You need to report to the Office of the Public Guardian. We've not even touched upon that. That's a policing arm of the Court of Protection. And they scrutinise everything. So all the income, all the outgoings, we send them the bank statements, all the decisions that I take on someone's behalf. The OPG look at that every year. And so there is a lot to being a lay deputy, and it is quite an onerous task, but sometimes it's appropriate and more cost effective.
Okay. Thank you.
But good question. Thank you, Janet.
I have loads of questions, but I'll keep my mouth.
Are there any in the chat? No,
there aren't.
No.
But,
okay, that's fine.
But the guys I know are happy to have their email addresses. Is that right? You're happy to have your email addresses put up. So if anybody does have anything
of course,
that's more detailed or specific to them, please send that.
Yeah, definitely happy to help any specific questions or follow-up questions.
Thank you, Jackie.
Thank you. Super, thank you. So thank you all very much. That was just so interesting, and I know we went over time, but I think we could probably have actually doubled the time and sort of that information, because it was just so interesting. And obviously we sort of we see bits of the sort of process in terms of our work and everything, but actually to have witnessed this session and all the previous sessions has just been so educational and interesting. It's been absolutely fantastic. So yes, thank the three of you very much for joining us today, and thank everybody else as well who came to listen to the sessions, this one and the previous ones. As with all of the other sessions, we will be editing the recording and posting up on our website, and I think Jackie might pop a little link into our webinar page. Thank you, Jackie, who is behind the scenes, and yes, and there'll be some fact sheets there as well. So yeah, it's been an extremely interesting session about looking at the whole litigation claim. So thank you all, and also thank you to Helen Brew-Gerlach, who behind the scenes at Irwin Mitchell has enabled all of this to happen as well. Helen, you've been brilliant, and yeah, so it's been a fantastic session, and we're going to be sort of putting all of the three sessions kind of together so everybody can easily kind of watch them, so that at any stage when people are thinking, okay, well, what happens at the beginning, or what happens at this sort of stage, or what happens, obviously post settlement, then they have that as a resource to listen to and to get some information. And I think this will be extremely helpful for parents who really don't know anything about the litigation process to be able to dip in and look at all of the information and listen to the information. So yes, so thank you all again.
Thank you guys,
Laura,
brilliant.
Katie. Thank you very much for the invite.
Great session, thank you.
Thank you very much for having us.
You're very welcome.
Thank you.
Super. Well, thank you everyone for joining us, and we hope that was very interesting, and we will now say goodbye to everyone.
Bye everybody.
Bye.